In the news this morning, formula milk prices are on the rise as competition authorities begin examining market. UK Chancellor Philip Hammond shuns Brexiteers' misconstrued call for a post-Brexit Singapore model. And more disgruntled commuters as MRT hit by further disruptions. The Competition Commission of Singapore is currently undertaking an investigation into the market for formula milk, as prices are found to have more than doubled in the past 9 years. Joining us later in the studio is competition law expert. We're actually now receiving breaking news of a dawn raid being carried out at the head office of NUS Milk Company, the leading formula milk producer in Singapore. I think we have our correspondent live at the scene now. What can you tell us, Marie?
Good morning, Alex. I am now reporting live from the business premises of NUS Milk Company. What you see here is the scene of a dawn raid conducted by the Competition Commission on NUS Milk Company, one of the largest companies manufacturing infant milk powder in Singapore. Typically, dawn raids are not made public in Singapore, but today we are lucky enough to witness a dawn raid as it happens for the first time. Standing behind me is the investigating officer from the Competition Commission who appeared unannounced about 20 minutes ago to search the premises for the purpose of investigations. Standing next to me is the manager of NUS Milk Company, and she is, to my belief, on the phone with her lawyer. Currently, the situation is that the investigating officer is waiting for the lawyer to arrive before proceeding with the search of the premises. Now, as this raid was seemingly unannounced, we can assume that NUS Milk Company is indeed itself under investigation, as the CCS can only conduct a surprise raid against a firm suspected of an infringement of the Competition Act. Against the backdrop of the CCS's market investigation of the powder milk industry, it is in all likelihood that NUS Milk Company is suspected of entering into anti-competitive agreements with its competitors. Now it looks as if they are progressing onto the premises, so let's have a look.
Where is your evidence of authority, and what are you investigating?
Yeah, of course. This is my idea, my investigation. You have the subject matter of this investigation and the purpose of it, and here is a list of my scope of powers. I'm going to enter now.
No, you cannot open the door without my consent until my lawyer arrives.
I have given you a reasonable amount of time for your lawyer to arrive. This investigation cannot wait any longer.
No, you have no right to open the door without my consent. Hey, what are you doing?
I have the power to use force, and it's reasonably to enter the premises. And I think it's reasonably necessary to do now.
My lawyer tells me that you cannot use force to open the door because you do not have a warrant.
Your lawyer is right, but I can ask you to open the door and use the force of law. So please open the door for me now.
As I said, I will not open the door until my lawyer arrives.
A reasonable time has passed. If you do not cooperate and open the door for me now, it's an offense for you to obstruct me discharging my duties.
Hey, what are you doing? You can't touch those.
Right, okay, but I can ask you to look through documents and find the document I want. Where is the list of the board meetings? Hurry up, I don't have... Okay, can you give me more explanation about this document?
I don't need to give you an explanation about anything.
Of course you have to. Give me some more explanation. I can ask you to provide some extra explanation.
Ask for explanations from him.
What are you doing?
I'm just trying to make your job easier.
No, you aren't. Put that down.
Hey, where's your authority? What are you doing here?
Well, it seems that we have lost connection with Marie, but joining us now on the programme is leading competition law expert, Professor Bertonia from law firm Scott & Clements. So what we just witnessed with the CCS in that investigation clearly demonstrates very wide powers. Is this illustrative of a typical raid?
Oh, good morning, Alex, and thanks for inviting me to speak on this program today. Well, there are three circumstances under which CCS can conduct a raid on business premises or domestic premises which are used for business purposes. Well, first, they can do so without a warrant and without notice, as we have just witnessed. Second, they can do so without a warrant, but with a 2-day written notice to the occupier of the premises. And third, they can do so with a warrant issued by the court. So CCS does have wide powers and discretion when conducting raids, but there are limits to the exercise of its powers. So, for example, the investigating officers can only take documents relevant to the investigation. And if the investigating officers have obtained confidential documents, they must preserve its secrecy if the company has identified the confidential document in writing. And the investigating officers cannot look at or take copies of privileged documents of the company, such as letters between the company and the lawyers, and this would also include communications with the in-house or foreign lawyers. So they also cannot investigate related companies, such as a parent or subsidiary company.
So can we say, for example, that the CCS has the power to ask people questions which they are then required to answer, or risk prosecution for non-compliance, even if an answer might incriminate them?
Well, yes, but self-incrimination is not admissible in criminal proceedings. So if we compare this to the position of other jurisdictions, for example, the European Union affords any person the privilege from answering a question by the competition authorities that may incriminate them. However, under Section 66 of the Singapore Competition Act, persons are required to answer any question by the CCS, regardless of the possibility of incrimination. Well, nonetheless, the normal rules of evidence continue to apply, and a self-incriminating statement will be rendered inadmissible in criminal proceedings.
So we're just about out of time, but just one final question. I mean, dawn raids. Surely this is the way we treat drug dealers, not milk formula producers.
Well, Alex, it's not really a dawn. As we saw just now, and the raid was at 9 a.m. And I think that is justified because you need the element of surprise to prevent undertakings from destroying or tampering with important documents relating to the investigations. And furthermore, the requirement of notice is only dispensed when CCS possesses reasonable grounds for suspecting that the premises are or have been occupied by an undertaking under investigation.
Well, I'm afraid that's us out of time, but thank you very much for joining us, Victoria.
Thank you, Alex.
Now time for the weather.
Hello there. There is sunny weather on the way for those who cooperate with the CCS. Put on the protective sunscreen if you don't want to be burnt by the commission. Ensure that you check that only authorized persons are entering your premises. Ask for evidence of their identity and authority. Ask to see the warrant if there is one. Check that it has been addressed to the correct person and that the CCS only searches for the documents specified on the warrant. Today's outlook is gloomy on your access to legal advice. The access you have is only granted at the CCS's discretion. Even so, your legal advisor must arrive within a reasonable time. If you don't cooperate, there might be a chance of thunderstorms. You will be struck by lightning if you commit the offense of refusing to provide information, destroy or falsify documents or information, or obstruct an investigating officer. Offenders may be fined or imprisoned for up to 12 months, or both. So keep dry with the compliance program to keep your employees informed about competition laws. The action of a single employee may expose an entire business to liability. Consult your lawyer on the implementation of the compliance program, and we will keep you up to date here. Have a wonderful day. Okay, we have to do it again.